Good afternoon, everyone. Good morning to those of you on the West Coast. Welcome to our program here today entitled The Next Generation of Nonprofit Executive Compensation, Providing a Competitive Advantage for Your Organization. My name is Jeff Tenenbaum. I'm the chair of the Nonprofit Organizations Practice at the Venable Law Firm, and we're pleased to welcome you here to this program, which, as many of you know, is part of a monthly series of seminars and webinars that we do for the nonprofit community on a pretty wide array of nonprofit legal issues and related topics. We have a great group of probably around 75 people here in our offices in D.C. for joining us for lunch today and for our program. And we have about 125 plus of you on the phone for a webinar from across the country. So welcome to everyone here today. We have what is, in my opinion, one of the most interesting topics that we deal with in our nonprofit practice here at Venable. And we have some absolutely terrific speakers to share their expertise with you here today, who I will introduce in a minute. But before we get into that, a few housekeeping matters. First off, for those of you on the phone and for those of you here in the room, just be aware that this program is being recorded, as we do for all of our programs. We started this monthly series back last April, and we've done at least one program every month. I think we did 2 in December. And we record all of these programs and maintain the recordings on our website along with the PowerPoint presentations for you and other colleagues and others to be able to tap into those after the fact. For all of you who are here in the room and on the phone, you will get an email tomorrow with a link to that recording along with the presentation materials. For those of you on the phone, you should have gotten already a link to the PowerPoint presentation. The link you'll get tomorrow will also include some additional resources we included in the handouts. Obviously, those of you here in the room have a printed bound copy of our handout book. A plug for some of the upcoming programs that we have, and if you're looking ever to find what are some of the upcoming seminars that we're doing on nonprofit legal issues, you can always go to venable.com/nonprofit/events, where you'll find that listing. And to find the listing of the recordings of our prior events, go to venable.com/nonprofit/recordings. I think this is the most pre-scheduled events we've ever had at any one time. We decided to go a little bit far out this time in terms of scheduling. On February 22nd, I don't have the exact topic names because not all of those have been finalized, but our topic on February 22nd will be in connection with international legal issues for nonprofits that are or are in the process of expanding their operations and activities overseas, and the various legal issues that come into play, very important legal issues. This has been an ever-growing area of our practice with nonprofit organizations. Our March 21st program will be on employee privacy issues for nonprofits. Again, a very hot topic these days in which we do a lot of work. Our April 12th program will be entitled 10 Best Practices for Protecting Your Nonprofit's Intellectual Property. We'll cover both copyright and trademark issues. We're going to be doing a special event on April 20th, the second event that month, featuring the author of a terrific new book called Good Counsel, involving what it takes to provide general counsel and other legal advice to nonprofit organizations. Leslie Rosenthal, the general counsel of the Lincoln Center in New York, a client of ours and a good friend, she and I are going to be hosting that program on that day. And then finally on May 17th, we're going to be having kind of a back to the basics session on nonprofit contracts. Nothing new and exciting, but a critically important topic for every lawyer, probably every CFO, and many other executives and CEOs that work with nonprofits. You know the importance of contracts. There are so many pitfalls and tips and suggestions and things that we've learned over the years from doing this work, and we're going to share a lot of that kind of bread and butter basics and some pretty sophisticated advice with you there on that program on May 17th. So a pretty good lineup coming up. In terms of the logistics for today's program, we encourage you and we'll be taking questions throughout the program. So for those of you here in the room, just raise your hands, and I'll be serving as moderator, and I will kind of call on you at the appropriate time. But don't get offended if I don't call on you right away. If our speakers are in the middle of an important line of thought, I'll probably have them let them finish until they finish that train of thought. In addition, if we get a whole bunch of questions on something, we may take a few and then have to defer because we don't want to especially be dealing with questions that our speakers are already planning on covering later in the program. So just work with us, but do feel free to raise your hand and ask us questions throughout. And for those of you on the phone, utilize the chat feature on the webcast. I'll be monitoring that from the laptop here in the front of the room, and we'll pose those questions to our speakers at the appropriate times. Finally, one more link I wanted to give you. We have a lot of resources, as many of you know, on our website on every imaginable nonprofit legal issue, at least 600 plus articles and PowerPoint presentations, including a number on the tax and governance issues that you're going to hear about here today. You can find all those at venable.com/nonprofits/publications. Finally, I'm going to introduce our speakers and then turn it over to the real experts here today. First off, my colleague in the middle here up on the podium is Matt Journey. Matt has been an instrumental part of our nonprofit tax practice, especially our nonprofit tax controversy practice, our dealings kind of vis-a-vis and against the IRS in connection with 100-plus IRS audits and appeals and now tax court cases and other matters where we've gone up against the IRS in connection with nonprofit tax issues. Matt has been an absolute superstar in our practice, has had some remarkable successes, and is not too modest to not boast about it. You'll probably hear some of that from him today. Extremely knowledgeable, extremely proficient, and extremely aggressive nonprofit tax lawyer. Matt came originally from the IRS Exempt Organizations Division, and then moved on to Ernst & Young's tax practice in Boston before joining us a few years ago. Matt's insights that he's going to share with you today are particularly informed from the dozens and dozens of cases that we've had against the IRS, and even now in tax court, where nonprofit executive compensation has been a central issue. So you're going to benefit from a lot of those experiences in terms of the advice and suggestions that Matt will pass on to you today. To my immediate right is Andy Lewis. Andy is a principal in the human capital business of Mercer, the Mercer firm, specializing in assisting tax-exempt organizations design and deliver innovative executive and broad-based employer reward systems. Andy's based in Chicago and has worked with a wide variety of tax-exempt organizations, assisting them in addressing complex issues. In the area that we have worked most closely with Andy has been in terms of compensation studies, particularly for larger, sophisticated nonprofits that need to be able to benchmark and document and justify the compensation that they're paying to their chief executives. Andy is very highly regarded in the field, and I can tell you from personal experience, extremely good at what he does. We've brought Andy in with a number of our clients in structuring and defending compensation arrangements for top executives, and you're going to be the recipient of a lot of really useful, insightful information here today. And to my far right is Julie Donnell. Julie is an associate in the human capital business of Mercer. Julie works closely with Andy, has really been kind of his right-hand person in this particular area, is extremely talented. We've also worked closely with Julie. She's worked on numerous compensation and talent management projects for tax-exempt private and public organizations in the healthcare, manufacturing, financial services, consumer products, and technology industries. Julie is also based in Chicago. Our speakers are going to be kind of jumping back and forth today. They're going to be speaking to you from the podium here. And again, I'll remind you to ask questions as we go along. And with that, I am going to turn it over to Andy, who's going to get us started. Andy?
There we go. Do I have to reference slide numbers?
You shouldn't have to.
Appears to not be working yet.
That's right. All right, why don't you get started?
Okay, fair enough. So the purpose of our discussion today, which is on page 2, is to really talk beyond just the traditional compliance question, getting your reasonableness opinion, having your market study done, all of the sorts of things that have been historically the discussion points for executive compensation in nonprofits, and to move beyond that into an area that enables organizations that you all represent to be able to think more, to be able to think in a more sophisticated manner around executive remuneration. And I'm going to use the phrase remuneration a lot, as opposed to simply just the phrase compensation, largely because one of the very important things that you do in these kinds of assessments is to think about every economic benefit that an individual receives in return for their service to the exempt organization. And so it isn't just about cash compensation, it's about everything. And we're going to spend a bit of time today talking about how important it is to understand the components of remuneration and how they are really important to be drivers of your organization's mission and your organization's strategy. So there's a number of topics on page 2 there that we're going to go through today, and Matt and I and Julie are going to go a little bit back and forth on different things. But ultimately we're going to go through these essentially in sequential order. But we want to understand the social and regulatory and perception issues associated with executive compensation. So what's the IRS doing? What are other stakeholders looking at when they think about executive compensation? And what do we mean when we say it's not just about compliance, but it moves beyond that? How do you then use this notion of disclosure and increasing transparency to help not just define your remuneration strategy, but to use it as a way to help really provide oversight to the compensation programs as well? We're going to talk about some red flags, both from a legal perspective as well as from more from a broader executive remuneration perspective as well. So I'll talk about things that I see in the marketplace, and then Matt will talk about more from a regulatory perspective. We're going to spend a bit of time talking about risk mitigation, because obviously that's very important. What can you do as an institution to help mitigate the risk associated with the types of issues we're talking about today? We're going to talk about how important it is to have, and everybody hears this. I mean, this is old news, but it seems to roll off the tongue as if it's an obvious thing, which is identifying goals and developing solutions like business strategy and executive compensation. I mean, everyone's heard that, and everyone repeats it as if they really know what it means. So we're going to spend some time today actually talking about that, and actually saying that it isn't just about open-ended commentary about how you target pay and what you want to do. It's much more important than that. It's much more of a process, and we're going to talk a lot about process today. And then we'll talk about the reasonableness opinion, and moving beyond just the fact that the reasonableness opinion has a very important protection associated with it, but also to talk about what needs to be in it and how to use that to help educate board and the management team, as well as other stakeholders that might have an interest in understanding how you made certain decisions that you made. And we'll talk a little bit more about instituting those policies and procedures that can help protect you. And then lastly, we're going to spend some time discussing the role of the compensation committee or executive committee, or in some cases the entire board, whatever the governance structure you have is, and talking about the importance of clear delineation of accountabilities of the board, the management team, and the outside advisor, and how important it is to do that to avoid any potential for confusion or miscommunication.
Before I get started, I think that it's only fair of me to warn you that the last time I gave a presentation, it was so powerful that the earth actually shook, and there was an earthquake in D.C. The Washington Monument was damaged. I'm going to try to tone it down, but some things are just too powerful to really rein in. So in the case of an earthquake, don't leave the building. We learned that last time. But just stay where you are or possibly go to a doorway. That's the warning. The clicker's not working again, so I don't know what to do. So I'm moving on to the third slide, which really just introduces the fourth slide. So going on to the fourth slide, the first question that I am asked whenever talking about executive compensation, whether I'm talking about it with the executive himself or with people who work and improve the executive's compensation, is who cares? Who's paying attention? Isn't this really just overkill? I'm not paid too much. My salary is reasonable. I work really hard. So what I really want to do is sort of provide you with an understanding of who is paying attention, why this is important to others, and how the importance to others impacts you and impacts the executives at your organization. First of all, who cares? First of all, the IRS cares. There are all sorts of rules and regulations that protect both donors of exempt organizations and the public from the abuses of using the exempt organization format to provide excessive compensation in an untaxed setting. There's also donors that care. Donors are very much mission focused. They want to make sure that their money is going to the goals that they have for it when contributing to your organization. For C6 organization, your members care. Members are paying your organization to accomplish certain purposes, and they want to make sure the funds are used for those purposes. Beyond that, we also have the media, which we'll get into a little bit later, competing organizations that are going for an ever-decreasing pool of available funding out there for organizations. Stuff like compensation can be used against you by other organizations who are competing for that same money. Additionally, we have competing interests. This is something that's actually been fairly recent in what I've seen, that organizations are actually being formed as nonprofit organizations for the purposes of attacking other nonprofit organizations that are aimed at achieving a certain social end that certain people don't agree with. So they form their own nonprofit organization to go after that and give it a veil of credibility. So in that situation, it's important that your organization from top to bottom is in very good shape, and executive compensation is an important part of that. And then last, your employees, your executives, your target executives, and this creates sort of a competing interest where all the prior people listed, all the prior groups listed are concerned that you're paying too much. But executives and target executives are concerned that you're paying too little. Most people clearly believe that they should be paid more, and it's obvious. But this is an interesting dilemma for an organization, trying to keep both sides happy so that you achieve and are able to obtain very qualified executives, but at the same time don't alienate any of these other groups that are out there actually paying attention to this and trying to keep you in check. The important part of this is the public perspective, because everyone has a perspective on this. And whenever someone is thinking about their own salary, I think about how much I get paid, and I think it's entirely reasonable because I spend so many weekends in the office. I get to the office every morning around 4:30 in the morning. I work hard. I work really hard, and everything I'm paid, I earned. But when I look at other people's salary, I'm pretty sure that I can do anyone else's job as well or as better than them, and I'd be willing to do a lot of people's job for a lot less money. I think that I was telling someone earlier, I'm a very big Chicago Bears fan, and while I have a lot of respect for Jay Cutler, I am willing to bet I could take 17 sacks a game for the same price he does. I would do it happily. But there are reasons certain people are paid certain amounts and others are paid others. So it's important that we keep in mind other people's perspectives when we're setting compensation and when we're justifying compensation. For instance, IRS, if you're under an examination, the agent that's going to be examining your organization is educated. They're an accountant. They have a professional education. They have a professional degree. But they probably make somewhere in the neighborhood of, depending how long they've been there, $25,000 or $30,000. And so if your organization executive is paid $1 million, that person is going to say, well, I'm a professional too, and I live on $30,000. Why aren't they doing that? Also for C3s, it's important to know that the IRS agents look at organization executives as people who chose to work at a C3 for the purpose of achieving a social end, not necessarily for making money. And so they are going to look harshly at and consider it a personal affront, not all agents, but most agents that I know, for executives that earn a lot of money. And this is something that they take very seriously and something they pay a lot of attention to. Also, other people that pay attention to this are donors and members. They want to make sure that their money is not going to line the pockets of whatever executive. They want to make sure that it's achieving the goals that they have in making a donation or joining a group. The media loves, especially now where we have this high unemployment, there are lots of disparity between salaries. The salaries are great news. I remember about 8 months ago or 10 months ago when people were protesting in Wisconsin for cuts in bargaining in public employees, and Fox News going on and on about how all the teachers were overpaid for essentially a part-time job when they're making $50,000 a year. And then a month before, they were talking about how the executives on Wall Street were underpaid, if anything, for making millions. So the reporting's not consistent, and a lot of it's done for the purpose of rating. So it's a sensational type of reporting, but sensational reporting at your expense or the expense of your organization is something that is not good. And so then you also have your employees and the executives that you have. You want to have a high enough salary for your executives that if someone leaves or and you're looking for a new executive, people are attracted to work for your organization because you need talent. At the same time, if you've got a very talented executive, you want to make sure that you keep that very talented executive. So it's important that you're balancing these out and maintaining the understanding of everyone's perspective when you're doing this. Who's paying attention and how are people paying attention? When looking at the IRS, this is the focus of this slide, the IRS is paying very close attention to executive salaries right now. In speeches, like the quote up there from Peter Lorenzetti in the first bullet, the IRS is saying that executive compensation is a #1 issue. In the compliance projects that the IRS are starting, which is sort of how the IRS focuses on their examinations, one of the main focuses is executive compensation. That's a problem they're seeing, and so they're training their agents right now to identify issues and potential problems that would indicate problems or potential problems with executive compensation so that they can focus on that issue during exams. So this is something that's very much an issue. With respect to 501c3 organizations, 4958, which imposes penalties on individual executives and board members and other executives who approve the compensation or benefits. 4958 imposes a monetary penalty on those individuals. So this is something that's very important to executives. We'll talk about it a little bit later, but this is something that the IRS hasn't gone after for several years. In each of the last 2 years, we've seen this raised about a dozen times each, which is more in those 2 years, in each of those years, than it was in the prior 6 combined. This is something that's very much an issue, and it's an issue that affects the pocketbooks of executives, and so it's very important. Moving on to the next slide, sort of seeing how it comes about and how this issue is really developed, we're seeing that competing interests in the media are using the media to cause attention and create problems for other organizations. Recently, about a month ago, I was watching HBO Real Sports with Brian Gumbel, and there was an entire episode devoted to the various bowls and the BCS, which are all C3 organizations, and the fact that another group, the Playoff Pack, was attacking those organizations. And where they got the most traction was on the compensation received by the executives of those organizations. The Playoff Pack was basically going through publicly disclosed documents for the BCS because as an exempt organization, their 990s, their 1023s, or 1024s are all subject to open disclosure. And they were going through, and through identifying salaries and other inconsistencies with expenses and benefits, showing that these organizations should not be exempt, first of all, and trying to get the IRS to conduct examinations, which could result in the 4958 penalty I just mentioned. Where they're getting a lot of traction is through things like the Real Sports program and 2020 and other types of programs where compensation is a sensational issue, and you're able to show a charity that is perceived to be doing abuses in a very public way. And the way that this organization is attacking the organization is through executive comp. Also, another BCS bowl game, the Fiesta Bowl, just last year, their executive CEO, John Junker, was fired. He was fired after Sports Illustrated and Arizona newspapers focused on his compensation. He was getting paid in the neighborhood of $600,000 a year for running the Fiesta Bowl. In addition to the salary, the things that really caught the people's attention were that he was receiving reimbursements for business expenses for very expensive trips to strip clubs. There were cruises to various luxury places that were paid for by the organization. He had a $33,000 birthday party on a golf course that was paid for by the organization. So there were all these other expenses. And the way that the organizations that are opposed to the VCS brought about his downfall, at least, was through focusing on salary and the problems with his salary and his compensation and the other benefits he received. So compensation may not be the biggest issue for an organization, but it's a very public issue, and it's an issue that other organizations have been able to hold on to and present to the media and really garner a lot of attention. And when you get that attention, it's not just the executive that has problems. Ron Junker, the CEO, lost his job and was indicted by a federal grand jury, which I've never been a CEO of an exempt organization, but those would be two goals that I would have to not have happen to me. But the problem isn't just with him, but the entire Fiesta Bowl at this point is tainted because he received the excessive benefits, but the board of the Fiesta Bowl approved those benefits. The organization was essentially run in a way that provided those benefits consistently over several years. There's a taint that stays with the organization that cannot just be undone by replacing the executive, because now there's always going to be questions. They've approved these benefits before. Are they going to do it again? And there's going to be constant scrutiny for that. In addition to the competitors and competing organizations, you have competing organizations saying, if you have two organizations going after the same finite pool of funding that's getting smaller, the other organizations will be able to look at your Forms 990 and say, wait a second, if you look at this organization, this other organization, they're paying way too much to their executives. They're not putting enough towards cancer research or whatever other activity it is that you're doing that you want the money for. You shouldn't give money to them. You should give money to us instead, because for us, we're not just lining the pocketbooks of the executives. We're actually doing this research. And there's all sorts of reasons that compensation varies. So it's not fair to you if you're just to be sort of put in a position where your numbers are used against you without a context. So that's something that we're going to be talking about throughout the presentation as well.
Yeah, I was just going to add that that's a pretty critical area of explaining to stakeholders what's on your 990, because all too often the numbers that are showing up on there are misinterpreted, and particularly around things like deferred compensation. Okay, and so one of the things you have to be sensitive to is having a strategy to address if somebody misinterprets, or ideally being forthcoming with that, and for using the various sections of the new form to provide the discussion around how you've made certain decisions. So as opposed to burying it in a footnote, where nobody is likely to see it, bring it out as part of your discussion around how you arrived at those particularly benefits. I mean, generally what happens is it's the benefit of retirement costs that tend to be the things that surprise people. The salary information on the new form is relatively straightforward. It's clearly laid out. You can see what someone's salary is. You can see what someone's bonus is. There's this euphemistic other compensation column, which seems to be up for a lot of confusion, but again, is generally where prior year deferrals have been vested. And so being able to have some of that clarity around exactly what you were doing avoids the risk that a competing entity looks at this and says, see, they're overpaying, when in fact this executive just got 20 years of retirement paid out in one fell swoop, and the reason it showed up is because that's the way the vesting rules work. So just an example of that in a sort of living environment. So give us a question over there, Jeff.
Is there any such thing as an acceptable expense ratio, say executive compensation to the total pool of money or something like that?
So what you're saying is there are there any sort of guidelines as to what executive compensation should be as a percent of donated funds or a percent of budget or something like that. I certainly haven't seen anything like that. What I tend to see are questions that pop up where people say, what is the CEO's salary as a multiple of the average employee? That's a question that comes up. I'm not suggesting it's necessarily a statistically valid argument for establishing what CEO pay should be, but I'm saying that it's one of the things that's likely to get brought up. So what I typically tell the boards that I work with is be prepared for all of these different contingencies. As an example, and we'll talk about this a little bit later, one of the things that we always do is we say, here's our, we work together, we develop the peer group, we understand what the comparable statistics ought to be, and you gather those from various sources and whatnot. But a lot of times what we'll do is we'll say, here are the specific, here's what particularly CEO, let's just use CEO as an example. Here's what CEO pay for nonprofits in this particular environment or this particular town are paid, okay? Even though they may not necessarily be true peers in a literal sense of the word. They are peers in the sense that the media and other stakeholders are going to look at you go to any major metro area around the country, every newspaper does a story at least once a year on top highly paid nonprofits, right? And they run the list down, and most of the time they have no interrelationships with one another. They're radically different revenue scopes. They're completely different industries that they operate within. But there's an assumption of similarity, if you will, by virtue of the fact that they've been clumped together in a list in a newspaper. So the board having an acknowledgement and understanding about what others in the area are paying, even if it's not used for actually determining the compensation of their CEO, is an important protection, I think, that allows them to at least be aware of what's going to happen in the paper.
And the last group of people paying attention are your organization executives and target executives. Or an organization executive that is negotiating their contract can hear an offer and go to GuideStar.com, pull up the 990s of their competing organizations and say, wait a second, your offer is 20% less than everyone else is getting. Why am I getting such a low offer? Which leads to discontent or a harder negotiation. So knowing where the pay scale is important there too. What are the risks of overcompensation? In addition to what we saw with Mr. Junker and losing his job and being indicted by a federal jury, the risks as far as the IRS concerned are revocation of the organization's exempt status for, if you're a C6 organization, it'd be for inurement. If you're for a C3 organization, it could be private benefit, private inurement. But in addition to private benefit and private inurement, for C3 organizations only, there's 4958, which I mentioned before. 4958 imposes an excise tax on excessive benefits received by insiders of an organization. The excise tax is on the excessive amount of the compensation, and the requirements are that the individual who receives the excessive benefit has to pay an excise tax of 25% of that benefit to the IRS. In addition, the individual has to return the excessive amount of the benefit to the organization. And on top of that, for participating in the transaction, the individual could be assessed a 10% tax of the excessive amount of the benefit. And if the individual does not return the excessive amount of the benefit by the time the tax is assessed, the individual will no longer be required to do that. But instead of that, the IRS will impose a 200% excise tax on the excessive amount of the benefit in lieu of making the individual return it. In addition to that, the board and others who participate or approve without standing in the way of an excessive benefit transaction can be assessed a tax of 10% of the excessive benefit. So trying to sort of put that in perspective with numbers, if you are an executive of an organization and you get paid $400,000, and the IRS comes in on examination and says that reasonable salary compensation for your position is $200,000, the first step in this is that the IRS will assess a $50,000 tax on you for the excessive benefit. then the IRS will force you to return the $200,000 excess to the organization. And then on top of that, the IRS could assess a 10% tax of $20,000 on you for participating in the transaction. That means that your salary will have gone from $400,000 to $200,000 because you had returned $200,000. And on top of that, you have to pay a tax of $70,000, meaning your take-home pay goes from $400 to $130. The second step is if you don't return it, the numbers change a bit, where your $400,000 salary has an excess of $200,000. You have initial $50,000 tax on the 25%. On top of that, you have a 200% on the $200,000, which raises it to $400,000. And then you have the 10% tax, which is $20,000. Then your salary of $400,000 results in payments to the government of $470,000. Also, you don't get a deduction for that amount. Your payment in your taxes in year one are based on a $400,000 salary, and you're not allowed to amend those returns. So it's a very, very harsh penalties. And if you are the board that approved that, any member of the board can be assessed a 10% excise tax for participation, which would result in a $20,000 penalty for each board member. Though actually that's capped at $10,000. I'm wrong. So it's actually a $10,000 penalty for each of the board members. So this is something that if you are an executive, excessive compensation is very important to you strictly from the IRS's ability to penalize you. If you're a board member, most exempt organization board members receive no compensation. So a $10,000 penalty for voting yay in a meeting is a big penalty. And finally, if you are in compliance, then somehow otherwise approve the salary or work with the board to approve the salary, and your CEO has to pay $470,000 in taxes, you're not going to have a job, so it's also very important to you. So this is an issue that, as I said, this is for 501c3 organizations only, but it's an issue that is very important to 501c3 organizations. It's important that your compensation is justifiable, both to avoid the public pressures and public perceptions, but also to avoid the very severe penalties. And looking on to just more of the other risks, you have your donors and members. Are they going to be unhappy with you? Are they going to be less likely to become members? We've seen organizations or industries where there was a C6 organization that had long been the association for that industry, but for some reason or another, a couple of the large members of the industry were unhappy and sort of funded a new organization to sort of take over the role as association for that industry. And the old organization, once the big money leaves the organization, goes away. You have the media, which you mentioned before. You also have your own employees. We don't see this often. Most employees don't realize they can look at executive salaries online, but once they do, they go and look because executive salaries are very interesting. So you can end up in a situation where if your employees are not also compensated highly, but your executive is, your employees can be very discontent. It can lead to high turnover. Every individual, there are good individuals and bad individuals at every job, no matter how low in the organization, no matter how high in the organization. And if you start alienating employees, you're going to start losing the very best individuals for your positions, even the ones that aren't the top level executives. So it's important to keep that in mind too. And finally, it's also important to keep in mind that if you are overcompensating your executives, you may not attract the executives that you want to attract. You may attract, if you are a C3 that's mission focused, you may attract executives that just want the money, that don't care about the mission. So this is something that's important to make sure that you're not just compensating to attract people, but you're compensating to attract the right people and the people that best fit your organization. Oh, and one more point.
Yeah, I just wanted to add that one of the longer term sort of effects that I've seen is that in cases where there has been a scandal or an issue around executive pay, what tends to happen, at least what I've observed, is that the board gets quite skittish. Okay? And so what ends up happening is that for years after that, there's a tendency to be overly cautious as it relates to compensation and overly involved in process. And so you create great inefficiencies associated with pay administration, and what ends up happening as well is that you have a tendency to not actually provide the level of compensation that's in fact necessary to be competitive. So you get this perverse scenario where the circumstance that caused this was overcompensation, and then there's this reaction that actually flips to the other side. And it causes a real issue associated with getting the right kind of talent in the door.
But in addition to there being risks of overcompensation, there are risks of undercompensation too. First of all, are you going to attract the appropriate talent for your position? Also, will you be able to keep the talent you have? You never want your organization to be seen as a stepping stone job to a better job. You want your organization to be a destination job. People work harder at their destination jobs. People are more fulfilled at their destination jobs. But if your job is a stepping stone because you're not compensating enough, it's going to be hard to keep the talent. There are also situations we've seen where undercompensating for several years has led to overcompensating in one. Just recently, in fact, on Monday, we were contacted by an organization that had been paying their CEO, who was instrumental in the founding of the organization, very committed to the organization, a very low salary for his entire career. Like, he hasn't even had a cost of living increase for the last 10 or 20 years or something like that. It's really a low salary. And he now wants to retire and doesn't have enough money to retire because he's been paid almost nothing all these years. And the organization has the money to pay him now, but the problem is that the organization, when they report it, is going to have low salary, low salary, low salary, low salary. Then 1 year where his salary quintuples, and the organization is going to have to explain that. And so by undercompensating for all those years, he wasn't able to save for retirement. He did it because he was committed to the organization, but now they're in a situation where they have to figure out how to find a way to get him more money so that he can retire, and the organization wants to help him because he's been helping them for so long. So now that we've identified the problems of overcompensating and undercompensating, and you can't just not compensate because that's even harder, we're going to look at using your disclosure to help define your situation. Some of the things that we're going to look at are some things that are important are understanding the information that's disclosed to the public, understanding what's in the 990s that the public can look at, and how those 990s are used, and how other organizations disclose this information, how you can learn from other organizations to sort of adjust your strategy and really try to find the solution that's best for your organization. And then also it's important that you talk about who the right experts are and sort of how they are able to help you and what information is available to you to make these decisions.
So one of the things that I'm particularly passionate about, as shocking as it may seem that I can be passionate about executive pay and so on, but I am. It's my chosen field. Is the remuneration strategy. And so all too often I think what you see, and this is not just in nonprofits, I think it's an issue that folks run into, which is there's a tendency for the executive remuneration strategy to be an afterthought, okay? It tends to get, all too often again, developed almost post-data gathering, or sort of shaped to match what the circumstance is, as opposed to help drive and define what the organization wants to be. And what I mean by that is that the remuneration strategy really needs to be born from the business strategy. Now, even if you're a public charity 501c3, you should have a business strategy. You are still a business. You need to have a strategy that defines the objectives of the institution over this certain period of time. Likewise, in order to understand the types of compensation components, salaries, incentives, retirement plans, benefits, you name it, that you need to use, and the mix of those different components within the entire program, that has to be a function of your business strategy, okay? So a classic example is all too often I run into situations where an institution will position themselves or legitimately be in a very high growth environment, okay? So they're a growing organization. They have that as a key component of their business strategy to grow double-digit percentages over the next several number of years. And then when you look at their executive compensation program, it's heavy on salary and heavy on fixed benefit and retirement programs. Well, a classic scenario for that would be, well, you've got a disconnect between the drivers of your compensation program and your business strategy. Likewise, the cases where people are in fact mature and stable institutions and don't have high growth objectives, yet they have huge percentages of compensation that are at risk in variable pay plans, very little compensation around retirement programs. And you have to raise the question, is that an inconsistency between the type of institution that we're purported to be and want to be, and whether or not we're delivering the compensation in a manner that's the most effective? Okay? So those are the kinds of things that really get behind how you use the business strategy to help define your remuneration strategy, as opposed to just saying, well, we want to target the median of the market for base salary, the 75th percentile for base salary plus incentive, and we want to have modest but not market-leading benefits and retirement plans. I mean, you hear those kinds of things a lot, and they're almost, sometimes you hear folks say, well, what are other organizations doing on their remuneration strategies? And to some extent, that's important to understand because you get a context of what others in the industry are doing. But ultimately, it has to be driven by your own organization. It has to be driven by your own business strategy. And so that's a key, in our opinion, a key component of understanding the message associated with the executive compensation program. Okay? So when you're putting together the remuneration strategy, it's important to think about it from really three core perspectives. Okay, the first, of course, is the institution itself, and so what is the history? What are the goals and objectives that have traditionally been used to define performance goals? What's the cost associated with these programs? Okay. Then you think about whether or not, again, as I just said, is it supportive of the overall business strategy? Is it something that's really a tool that's used by the board to help drive that institution's business strategy, as opposed to simply a discontinuity, frankly? And then you need to look at it from the stakeholder perspective. So what's the outsider going to look at from this? So everything from the individual recipient of the compensation to the media to the donors to the other employees in the institution, the other members of the board. Keep in mind too that in most cases you're delineating or delegating, I should say, the authority of executive compensation to a compensation committee or an executive committee. It's very important to make sure that the committee has the appropriate level of interaction with the full board. In most organizations, of course, the board is approving the CEO's compensation, but it needs to be a more involved and thorough process whereby the full board has the opportunity to understand the deliberations and the process that the committee went through, as opposed to simply just signing off on the committee's recommendation. In many cases nowadays, what I'm doing is I'm attending those board meetings with the committee chair as a way to help the board understand the decisions that have been made and to provide that outsider's viewpoint about how compensation decisions are increasingly very complex and not just open a survey up, pull a number, and put it in a spreadsheet. Okay. I essentially discussed page 17 already, so I think we can move on to some of the red flags.
For these first few slides, I'm going to fly through them pretty quickly. I just wanted to sort of point out information that is available to the public and where the information is available. I wanted to show organizations where the information that people will be judging your organization on comes from. For instance, in the 1023, the form that 501c3 organizations file for purposes of being exempt, the information in Part 5 requests information that is specific to compensation, such as the amount of compensation, the title of the individual, the name of the individual, but it also asks for the qualifications of the individual. We've seen lots of 1023s where people just attach resumes in response to some substantial part of this information. This information is all available to the public. That resume and that salary will be compared to each other. People will be able to look at your 1023 and say, wait a second, I have very similar qualifications. How come I'm not getting paid this much? Or other executives will look at this and say, I've got very similar qualifications. My organization's paying me too little. I'm leaving. So it's important to keep this information in mind. The 1024, which is filed by other exempt organizations that are not C3, requires substantially less information, but does require the names, the address where the executives can be reached, and the amount of compensation that's paid. The most up-to-date information is on the Form 990. And the Form 990 requests a substantial amount of information about compensation. And the information that's included includes information about the policies for approving compensation. Organizations are asked whether or not they have a conflict of interest policy. They're asked about to explain the compensation approval process. Information like this, if you don't have a conflict policy, if you don't have a compensation policy, this compounds the perception that your compensation is too high if your compensation is already on the high side. Because the question is then, they pay all this money, what's the oversight? I can't tell if I'm on the right slide or not, but looking at the information on the 990 requires the amount of compensation for current and former individuals, such as executives, key employees, highly compensated employees. The other parts of the 990, Part 9, has a statement of expenses where one of the questions is ask for information about the highly compensated or management's expenses for compensation. And people can compare management compensation directly to the organization's other expenses. If you're a donor worried about high compensation of executives, the question that was asked earlier, is there a sort of a rule of thumb that you can sort of follow? There's no rule of thumb, but any individual may look at this and say, wait a second, their executives are getting 50% of their total expenses. That seems way too high for me, and decide to find another organization to donate to. And then you have Schedule J, which is specific for compensation. It has very specific questions, including looking at types of benefits provided. There is not yet a box for strip clubs or $33,000 birthdays, but types of travel there are questions about that. And what I didn't include on here is Schedule O. All the information that the IRS asks, whether it's for a number, whether it's for a yes or no answer, it's all very black and white and doesn't have any color to it. You don't have any sort of understanding of why the number is what it is. Schedule O is just a series of blank pages. This is your chance to say the compensation is what it is because, and you explain it. You explain that the reason that first class and private jet travel is permitted for your executive is because your executive spends, 300 days a year on a plane. And it would be impossible for your executive to really accomplish their job if they didn't have the extra legroom needed to sleep on a plane that first class provides. There's a reason that people get certain benefits in most cases. If you've got a reason, explain it, because you don't want someone to say, wait, I don't get to fly in a private jet. Why should they? It's important that people understand that the private jet isn't necessarily an added benefit. It's something that's necessary for the person to function in their position.
And Matt, let me interrupt for a second. This is Jeff. In this whole area of expense reimbursement and what we call working condition fringe benefits, business-related expenses that the executive or top executives will either get reimbursed or paid directly on their behalf. This is a critically important area. It's an area also where the IRS has really cracked down. And while most, if not all of you, may not have the luxury of being able to fly private jets to do your business, there are many other kind of perks and benefits and expense reimbursements or things that are paid directly on your behalf that may or may not be 100% business related. And so when we're talking about overall total compensation, or as Andy says, remuneration, it's critically important that you take a very close eye toward all of these other non-cash expense reimbursements or things that are paid directly, everything from country club dues and expenses to cars to everything else, many of which are very justifiable, but also many of which we find constantly, and the IRS finds constantly, organizations and executives are not properly allocating out the amount that is for personal related use. For instance, the amount of a company or an organization provided car that you utilize to drive to and from work, that's not treatable as a business expense. That has to be treatable as personal income. And you need to allocate the value of that and allocate some amount to the business side and some amount to the personal. Same with country club dues, same with many other things that clearly have a strong business-related purpose, at least in part, but also have a personal component, and that personal component needs to be treated as income to the executive and paid tax on. And one thing that we haven't had time to talk about, but Matt, maybe you want to talk about this in about 2 minutes, is for 501c3 and 4 organizations, automatic excise benefit transactions. It's an area that the IRS has really rediscovered in the last couple of years, is really cracking down on, and is enforcing very regularly, we're finding in IRS examinations of C3s and C4s. And this is, in a nutshell, situations where the executive should have been treating some kind of an expense or payment that was made as income, but they didn't. And if you didn't, then the IRS can come in, even if it's not an excessive amount, even if combined with other compensation it's not unreasonable and above fair market value, they can apply an automatic excise tax on that amount and penalize you for that amount because you didn't treat it as income at the time it was received. Can be very costly, very embarrassing, and very troubling. Matt, anything you want to add on automatic excise benefit transactions?
We'll actually talk about that in mitigating risks, so we'll get to that in a minute.
Okay.
But in addition to sort of identifying the red flags, it's important to understand why they're red flags or what's important about them. For instance, the high salary or how you can do something about it. Almost every 990 I see, the organization puts down for the compensation that's provided, and then for hours worked, they put whatever the organization deems to be full-time. Sometimes it's 35 hours, sometimes it's 37 and a half, most times it's 40. And you see that every executive in the organization, every highly compensated person in the organization works exactly 37 and a half hours a week or 40 hours a week. If your compensation is $1 million and you put down 40 hours a week, individuals will look at your return and say, wow, that's a really good hourly rate. He's getting paid way too much. And in fact, there are situations we've had where the IRS, because the 990 is signed under penalties of perjury, has held an organization to saying, we're only going to assess your salary based on a 35-hour work week because in your 990, which was signed under penalties of perjury, you said that she worked 35 hours a week. And so when they broke it down hourly, because other organizations reported 40 hours a week, that caused a reduction in salary, and so her salary was deemed to be excessive. Primarily, for one of the major reasons, was because they put down less hours. They didn't put down the actual hours worked. When I talked to them about it, they said, well, yeah, I'm in the office at least 60 hours a week every week. Well, why didn't you say that? Well, because it was full-time, was 35 for us. Put down the actual hours worked. If you work 60 hours, 70 hours, or your executive works 60 hours, 70 hours, put down 60 or 70. It'll make that high price seem more reasonable. Don't lie, be honest that you are signing this under penalties of perjury, but put down the actual hours, not just sort of an estimate. But when looking at sort of how this is viewed by the IRS, the red flags that are seen in this form are paid attention to by the IRS. In the College and University Compliance Project, one of the big issues was that a number of organizations did not have contracts with their executives, did not have a compensation policy. They did not have a conflict of interest policy. They did not have, they didn't hire outside experts to determine the reasonableness of salaries or certain transactions. Well, through the compliance projects that discovered this, those are now questions on the Form 990. The Form 990 is reviewed by a computer. Every Form 990 is reviewed by a computer, and the IRS can easily decide put in a different pile the ones that don't have a conflict of interest policy, that don't have a compensation policy, and have a salary of excess of a certain amount. So you're creating yourself a target of yourself. In addition to that, by presenting certain red flags, not only are you a target for an examination, but when you're under examination, you become a target as well. The best defense is a good offense. If you are checking, yes, I have a conflict of interest policy, yes, I have a compensation policy, the IRS agent's job is that much harder because you already have these policies in place that establish a certain standard for setting salaries. The IRS agent then has to say that those standards are wrong as well as the salary being excessive. So it makes the job harder. And the harder you make an agent's job in assessing a penalty, the less likely you are to have a penalty assessed, at least in my experience.
And I would just add a couple of other thoughts to this, and that is that one of the advantages of the environment of enhanced transparency and governance that exists around nonprofit executive pay is that you can begin to ask yourself, I think, a very good question, which is, if you're going through this process and you find yourself having difficulty answering some of these questions in the way that you think you'd like to be able to answer them, it should raise a red flag that perhaps some things need to be reviewed. And that's something that, again, another important governance protocol here is that your compensation committee should be provided the opportunity to review the sections of the 990 that pertain to executive compensation prior to the filing of that 990. Okay? So it's important for the committee to understand how the decisions that they have made are reflected on the 990. Because let's keep in mind that, and I'll pick on deferred compensation again. One of the things that one has to do when you're doing a market study on or on total remuneration for executives is you have to normalize, if you will, the question of deferred compensation. So those of you who are familiar with defined contribution benefit plans, defined benefit retirement plans, know that there are radical differences in how those dollars look throughout an executive's career. So in order for an institution to be able to make a clear comparison of how they're structuring their, I'll call them just retirement plans to be generic, how they're structuring their retirement plans vis-a-vis the marketplace, you have to normalize and standardize for that. So you have to look at you have to look at the value over the career of the executive, you have to normalize it, and then you can make an annualized comparison on a dollar-for-dollar basis to the market and help make a determination as to whether or not it's reasonable. Well, the problem is that that's not how it necessarily gets shown up on the 990, because of course the 990 is a tax form. It's not a, it's not a proxy statement. So it's important to understand that a defined benefit executive pension plan, okay, is going to look, when the executive is 40, it's going to look pretty small. When the executive is 62, it's going to look gigantic. And it's going to, be the kinds of things that the compensation committee has to be very, very clearly aware of. So those are the kinds of things I think that are very important that's very important for the committee to be able to have some oversight around the disclosure on the 990. A couple of other red flags on this page here that I just wanted to point out. One of the things that we see as being a very important part of the process is making sure you have a very good comparison group. Okay, so you need to have there are certain industries, for instance, where without getting too geeky into the statistics, there are very close correlations between organization revenue and CEO pay. Okay, particularly, for instance, in large tax-exempt healthcare organizations, so big health systems and so on that are typically 501c3s, you tend to see a pretty close correlation between CEO pay and the scope and scale of the business that he or she is running. In think tanks or membership associations or other types of associations, there tends to be actually a very low correlation between CEO pay and the organization's size. It tends to be measured by other things like reputation and impact and and those kinds of things, which of course are less tangible. And so it's very important to make sure that the comparison group for your institution is clearly articulated, and that you have documentation that surrounds how the compensation committee, how the management team, and how the outside advisors all played a role in helping to shape what that looks like. Okay. A couple of other things on page 25. We see this in the for-profit space as well, but pay programs that encourage short-term actions. So it's important to understand that just like we're seeing critiques and concerns about this in the for-profit public company space, it's important to understand that how you structure the compensation program doesn't necessarily focus solely on those short-term objectives. That you have we are seeing not necessarily a big uptick in the use of long-term incentives, but long-term incentives have a reasonably high prevalence in nonprofits. And it's important to understand that there are vehicles that are appropriate to use to help drive longer-term objectives, particularly mission-type environments where something might be 3, 4, 5 years out that lends itself to an event-based degree of compensation that can, in fact, help to really reinforce what the mission of the institution is.
In addition to assessing the risks, mitigating the risks is also fairly important, I think, in my opinion. When we usually see clients raise these questions with us, the answer is inevitably too late, at least too late for the client. My personal preference, and my advice to you if I just want to get interesting work, this is not legal advice at all, but is to overcompensate all of your executives, take too much compensation, because as far as I'm concerned, examinations where an organization took all the risks and none of the precautions are a lot more fun for me because I get to be a lot more creative. As far as organizations are concerned, this is much worse for the organization. This is much worse for the individual executive. If I were to advise you legally, I would advise you to take precautions early. Right now, we're litigating a case in tax court where the IRS has assessed a penalty of about $2 million based on a transaction that really the compensation for the transaction was reasonable, and it seems that it should be objectively reasonable. The reason that the IRS has assessed the penalty is because the valuation report was done after the examination was complete. The legal advice sought on whether the compensation was excessive was done after the examination was complete. And at that point, the IRS had already made up their mind. They'd already gone after the penalties. And now I will win this case, but I will win this case at a cost of probably $400,000 to the individual, which is a lot less than the $2 million that the IRS has assessed. But had the organization hired Andy early, had the organization consulted me before the transaction, then they would have paid, I don't know how much they would have paid, but they would have paid substantially less than a quarter of the $400,000 it is to defend against the IRS once they make their mind up. So it's important to do this early. It's important to do this before the IRS is knocking on your door, because the IRS will view an invitation or view a lack of pre-compensation protection as an invitation to go after the organization. Who do you consult? Don't just consult your legal advisor. Don't just consult your accountant. I am really good at my job. I believe that I'm the best at my job currently. I don't think there's anyone that's as good as me. And honestly, I don't recognize any peers. I am fairly arrogant, but I am very good. But at the same time, I am not good at Andy's job. So if you come to me and say, can you do a salary survey and tell me if my compensation is good, I can't. Well, I can, but it wouldn't be good. It wouldn't be what you want or what you need. So you can't just rely on your legal advice. You can't just rely on your accountants. Far too many organizations do this. I'm dealing with a client that provided me the evaluations provided by their accountant, that they've been working with the accountant for a decade. They were going to enter into some risky transactions. They went to their accountant and said, value this for us. The accountant did it. There's now a federal regulator knocking on their door. They wouldn't let me review these compensation studies before the regulator started knocking on the door. And they're now saying to me, can I give these to the regulator? the valuations are horrible. I think I used in my assessment of them the words imbecile, incompetent, lazy, that these valuations actually do more harm than good. And it's because they just stuck with their accountant. They went to someone who was not an expert on what they went to them for and sought an expert's opinion. So it's very important that not only do you consult experts, but you consult the correct experts, and that you do it early so that you can assess your risk, you can mitigate your risk, and that you have an opinion. That is something that you're going to pay thousands and thousands of dollars for an opinion on valuation. It's important that you get your money's worth, and it's important that you protect yourself with it. Some of the specific things you can do, and I use the term intermediate sanctions here. Intermediate sanctions is the section 4958 of the code that I mentioned before, the one with the very large penalties on specific individuals, ones you want to avoid. While these steps I'm going to describe are specific to a safe harbor provided in the regulations regarding intermediate sanctions, they're also applicable to 501c6 organizations as well. They're applicable not in so much as providing a safe harbor, but these are steps that if you do these steps and you implement these policies, you will find yourself in a situation where you have provided more reasonable compensation, not just because you have a policy, but because the policy imposes certain actions that by themselves cause you to consider the salary more thoroughly and result in more fair compensation.
And I should add that the Form 990 for all tax-exempt organizations asks the question, essentially, do you have these steps in place? Do you follow these steps in setting executive compensation? So if you want to check yes to that box, you actually have to have these steps. Matt referred earlier to compensation policies. Every compensation policy needs to be very carefully tailored to the needs and unique environment and context of each nonprofit organization. But certainly at its core, these are the key steps that should be included in every nonprofit's executive compensation policy. Matt, sorry to interrupt, and just all our speakers, we need to speed it up a little bit to make sure we finish on time.
You can't rush perfection, Jeff. I'm sorry. Okay, faster. There's some of the general things you can do. Use caution. Have policies, the conflict of interest policy, the compensation policy. Those are important to have. In your board meetings, when you discuss compensation, justify why. Have your board members say, you know what, we are paying this person X amount because they have served the organization for 35 years and they've been underpaid the whole time. The IRS reads board minutes. They're going to see that and they're going to say that the compensation wasn't provided to enrich the individual, but to actually compensate the individual. Or we're paying this person this much money because we're a cancer research organization and this person has a PhD in a very specific thing that is really going to help our organization and help us as we start working in sort of achieving new things. Also, Jeff mentioned automatic excess benefit transactions a little bit earlier. Automatic excess benefit transactions are transactions that are deemed to be excessive simply because they are there and they were not previously recognized as compensation. If you do not have a reimbursement policy that requires some sort of overview or the maintenance of receipts, the IRS can come in and say, well, you reimburse this person $12 on this date, you didn't justify it as a business expense, and you didn't report it on the W-2, and you didn't say in your board minutes that this was going to be compensation, that $12 is an excess benefit. And so the person has to pay the $3 for the 25% tax and then return the $12 to the organization. I have seen the IRS actually assess a penalty on a payment as low as $74. So the IRS takes automatic excess benefit fairly seriously, and while $75 or $74, it doesn't result in a high tax and it's not a lot to return to the organization. It's an inconvenience, and it's something that the person is going to pay every time because it's not worth it to pay me to fight a $74 issue. So it's important that when your board discusses compensation, your board acknowledges that all of these payments are compensation. When you acknowledge that it's compensation and you approve it as a board, it's not going to be an automatic excess benefit no matter what. So that's important to do. It's important to have an effective reimbursement policy. Now, moving on specifically to the safe harbor for intermediate sanctions, there are 3 steps that you can do to create this rebuttable presumption of reasonableness. One, the board, your governing board, approves the amount of compensation before that's paid. So before you pay the salary, before you enter into the employment contract with your executive or extend the contract, your board votes on the contract. Your vote says this is reasonable compensation. That's why we're giving it to them. Second, the board, in reaching the determination as to reasonableness, looked at some sort of comparable, whether they looked at 990s, whether they consulted Andy, whether they talked to their accountant. They've got to consult something to sort of establish that the amount of compensation is reasonable. And third, they've got to have this written down and stated before the compensation is paid. Usually it's done in the board minutes, which are sort of gives the reasons for the compensation. And those three policies, as I said, the regulations are only applicable to 501c3 organizations. But by doing all these steps, by having the board approve it, by having the board review it, by having the board look at comparables, and by having the board be accountable by writing down what it is that they said and what they approved and why they approved it, you've sort of instituted procedures that will result in reasonable compensation simply because they exist. It's important to note that this is a safe harbor, but it is rebuttable. So if the compensation is very excessive, the IRS will still go after you. However, I've never seen an agent challenge a amount of compensation for which the rebuttable presumption was established, and there were some fairly high ones, just because it requires so much more work for the agent to overcome that presumption. And as I said before, the easiest way to prevent an agent from assessing a penalty is by making it a lot of work for the agent to do that. So I strongly recommend this.
So in the interest of time, I might just make a couple of comments about page 31 and then move forward more rapidly. But a couple of thoughts I wanted to share here is that, there is a movement afoot, if you will, that I've seen in many of my clients to really simplify the question of compensation and to really move away from many of the other types of benefits and perquisites that might have been familiar 10 or 15 years ago, and simply say, we're going to give you this compensation. If you choose to join a country club, or you choose to have a fancy car, or you choose to do whatever it is you want to do, go ahead and do that on your own dime. But we're essentially going to say that we find that the level of compensation we're going to give you is reasonable, appropriate, and competitive, and how you choose to spend it is, of course, up to you. So that's something that I think is an increasing trend that we've certainly seen, and certainly something we're advising too. We think it's cleaner. We think it's easier. It's more transparent to the community to say, here's what we're doing in terms of executive remuneration. And so, having the documentation that surrounds that is a very important part of assessing and mitigating risk. And so, we think that it sounds boring, but compensation committee minutes are a very, very important part of understanding how decisions are made. They also have a very important side benefit, which is when new members turn onto the committee, which in nonprofits, the churn on committee membership tends to be pretty high. Providing a summary of the committee meeting minutes over the last few years can be very, very helpful. Particularly when a new member comes in and might have a lot of questions and say, well, why do we do this and why do we do that? And then you're sort of all too often, I think, reliant upon the sort of the telephone game, if you will, of history in the institution, as opposed to having the clear and concise documentation about how those decisions are made. And to Matt's point, this stuff is not free. The process you have to go through is time consuming. It can be costly and this, that, and the other, but it certainly is a major factor in mitigating the risk associated with executive compensation. The next page just summarizes really this is just a broad summary of some of the important considerations around governance of executive pay. Again, having a good governance process, this is the nature of the automatic excess benefit transaction. Essentially what the IRS is saying is that because you didn't have a good, clear, and effective process in place to avoid this from happening, we're going to call it an automatic excess benefit transaction. So having some governance protocols in place that are very clear, very straightforward, transparent to all stakeholders makes a big difference in your ability to mitigate risk associated with not just an automatic excess benefit transaction, but any of them. So why don't we then move to linking business strategy and executive compensation. I've been talking about this theme throughout. There's a very standard consulting diagram here on page 36. We always like to have diagrams that talk about how we interact with different strategies, but all kidding aside, it's very important here to understand that, ultimately the executive compensation strategy is a function of the business strategy and the human capital strategy. So more broadly, how does the institution understand the role of human capital and what impact does that have on executive compensation? The last section is, second to last section is using reasonableness opinion as a way to educate your board and management team. So a couple of themes I just want to share here on page 38 is that really what we've seen is an evolution of the reasonableness opinion from a 2 or 3 paragraph commentary to something that in many cases, as we've worked together, is a really quite a comprehensive document that summarizes really everything around the rationale for the definition of the peers, the history of the individual executives, the performance and the services they provided to the institution, the unique facts and circumstances that ultimately help to define what that comparative information really ought to be, and then where within that continuum it's reasonable to consider paying that person, okay? So one of the things that I'm always advocating in favor of is that if you happen to be a highly compensated individual relative to your peers, it's ideal that you have a variable pay program, for instance, that has goals and objectives that are specific, measurable, difficult, externally verifiable, such that you can then position yourself to say, if I'm paying at the 90th percentile, for instance, that I happen to be performing at the 90th percentile as an institution. A concept that has become increasingly important, of course, in the public company world is now coming into the nonprofit sector with really with a vengeance. And so as more and more data become readily available, it's becoming increasingly expected by boards to say, okay, I might be comfortable with this compensation, but management needs to prove to me that this level of compensation is justified based on the performance of the institution. Okay? So it's those kinds of things that become very, very important when you're defining your reasonableness opinion, because ultimately that gets to your justification for how you've established your compensation. The next page just has a couple of thoughts around some considerations when you consider the overall. What are sort of the 5 takeaways? If I were to sort of sit here and say, I want you to have 5 takeaways here, they're listed here. Understand how to clearly delineate authorities between the board, the compensation committee, and the management team. All too often you see tension that exists between what the CEO thinks his or her decision-making authority is around executive pay and what the compensation committee thinks their decision-making authority is around CEO pay. So it's very important to make sure that that's clearly articulated in things like a compensation committee charter or executive committee charter or what have you. Document your compensation decision-making deliberations, not just what you decided. So this is an important part of that facts and circumstances test, if you will, which is you're providing the color commentary in your meeting minutes. It doesn't have to be overly flowery with language, but it needs to provide the level of detail that explains why you did what you did. Talk about the mix of pay. I talked about this before, which is if you are a very high growth institution and you happen to have no variable pay, to me that's an important thing to explain. Doesn't necessarily mean it's wrong. I just think it's important for you to explain in your process why you've chosen philosophically to have fixed compensation. And that may be something that's very important to the mission of your institution, that you don't want to have variable pay because it's not consistent with your mission, even though your business strategy suggests that you've got a high growth agenda. Okay? So there's important considerations that you have to take into account. Define the market from which you recruit or lose talent, and understand how other stakeholders will perceive that. So this is the scenario of a lot of particularly C6s run into this situation where they're competing with nonprofits, but they're also competing with general industry. And so you straddle this universe where, to some extent, you need to understand the marketplace or the for-profits, but you also have to have a leg in the nonprofit world to maintain that degree of reasonableness. And so understanding those factors becomes very important when determining how you establish the comparisons for compensation. And then, as I mentioned before, ensure that the reasonableness opinion fully delineates and explains the nuances of the facts and circumstances. I can't explain the importance of that enough. I mean, you really have to have a commentary about the mission, your exempt purpose, what really defines, particularly if you're a C3, how do you really quantify your exempt purpose in your community benefit? Okay.
Instituting the policies is important. I'm going to be really brief on this to try to go through it. The important thing in instituting policies is that they're not one-size-fits-all. Every organization is different. If you are on the board of a small organization that has $25,000 in revenue every year and about $19,000 in expenses, do not run to that organization now and say we need to have a compensation policy, we need to have a conflict of interest policy, it needs to accomplish X, Y, and Z. We got to hire Andy, an expert, to go out and say that everything is correct and that the compensation is reasonable, and we need a compensation committee. If you've got a 3-member board, having a 10-member compensation committee is ludicrous. Find the policies that work best for you. Find what works for your organization and institute a policy like that. The IRS has a good conflict of interest policy online that it approved. It's a good policy, but it's not perfect. It may not work for your organization. Look at that, consult the experts, and ask what works best for you. And when consulting the experts, consult the experts that work best for you. I've got a list of compensation experts on my computer that I update and change as I work with other organizations. If you think you're in trouble, call me up, say, hey, my number's on here, Matt, we need a compensation expert. Who do we hire? I'll ask you questions, give you a list of people that are very good, and you'll get to talk to them and you'll sort of narrow it down from there. Because it's important that you consult the right people and you consult the experts that will really help your organization. It's your organization, the solutions you have to be tailored to that.
I'll just a quick comment on enhancing the role of the compensation committee. I've essentially already talked about that, but I'll just leave you with the thought that it's very important to understand that the number of times that I come into an institution and I ask to see the committee charter and I ask to see the compensation philosophy and I ask to see the meeting minutes, and there's very limited information that's ultimately provided back because they just don't exist, is something that probably needs to change. And so, I think it's extremely important to understand the interplay, as depicted here on the last slide, between the outside advisor, both from a legal and compensation perspective, the management team, and the compensation committee, to ensure that the processes that you're following are fully understood and fully adhered to by everybody involved.
Two postscript comments. First off, I apologize for the running a little bit along on time and not having as much time as we had hoped for questions, although this is probably the fewest number of questions we've ever had for any seminar we did. Either that's a good or bad sign. I will take it as a good sign that our speakers are very comprehensive and covered everything. We also had hoped to kind of work in Julie down at the end of the podium with some color commentary along the way. That didn't quite work as expected, but we apologize to Julie, but appreciate her joining us. And finally, one specific comment, but it's very important and something we didn't mention. Utilizing your attorneys, your outside attorneys, to take advantage of the attorney-client privilege in doing compensation evaluations and studies is a very important tool, and it's something that we do quite frequently, including with some of you in the room with whom we've worked on these compensation studies, especially if you're not sure how the study is going to come out and you may not want to make it public or utilize it with the IRS. Having your attorneys, working through your attorneys, having them engage the outside experts like Andy, for instance, as an expert different as retaining them by the law firm and then having all the communications and the reports flow through the law firm back to your organization will help shield that within the confines of the attorney-client privilege, presuming you don't share it with any outside third parties and you just keep it within the board or the executive committee or the compensation committee. And that way, if it doesn't come out in the way that you like, you can essentially bury it and maybe redo it or go find another expert or whatever you end up doing. But if you simply hire the compensation consultant directly, there is no attorney-client privilege. And if you get audited by the IRS, you get hit with a lawsuit, or you get a regulatory investigation by a state AG, you're going to have no way to protect that information. With that, it's about 5 minutes after 2 Eastern. I want to thank everyone. I want to thank our speakers in particular for a terrific job today. Thank all of you for attending here in the room and on the phone, and I hope to see you next month on February 22nd for our next program. Thank you, and have a good afternoon.